bringing the appeal of Dominic Suraj and others against Attorney General of Trinidad and Tobago.
Yes, Mr. Knox.
My Lords, my Lady, in this matter I appear on behalf of the appellants together with Mr. Anand Ramlogan, Senior Counsel from Trinidad and Tobago, and Vishal Susharan, also from the Trinidad and Tobago Bar, along with Mr. Adam Riley of the English Bar. My learned friend Mr. Tom Rowe, Queen's Counsel, appears together with Mr. Fayad Hussain, Senior Counsel of the Trinidad and Tobago Bar, and with Miss Natasha Jackson, again of the English Bar, for the Respondent. My Lords, my Lady, you will have seen that this is an appeal against the order of Trinidad and the Court of Appeal of Trinidad and Tobago, made on the 20th of April 2021, which dismissed the appellant's appeal against the order of Mr. Justice Boodoo Singh on the 11th of September 2020. And in essence, in this appeal, the appellants say the courts below went wrong, and they seek a declaration that, contrary to what was held in the courts below, Regulation 3 of the Coronavirus Regulations, number 8 of 2020, which prohibits gatherings of more than 5 people, or prohibited gatherings of more than 5 people in a public place without reasonable justification, was passed without lawful authority and was therefore void. Therefore, they say in turn, their arrest on the 9th of April 2020 and their charge subsequently on the 14th of April 2020 were wrongful, and they could not and cannot be found guilty of any breach of those regulations. My Lords, my Lady, you'll see we say that this appeal raises 3 main issues. Did Regulation 3 of the relevant regulations prima facie abridge or infringe the appellant's freedom of movement or freedom of association and assembly granted by Sections 4 and 5 of the Constitution? Second issue is, if so, was it nonetheless saved as an existing law? That is, was the relevant regulation saved as an existing law by Section 6 of the Constitution? And thirdly, if the appellants are right, what declaration, if any, should they be granted? Now, what we say on these issues, in summary, my Lords, first, there was a clear prima facie abridgment, and I'm using the words of the Constitution, abridgment or infringement of the freedoms of movement and of association and assembly by Regulation 3. Second, we say the law is not saved, the regulation is not saved as an existing law by Section 6 of the Constitution. First, it does not come within the definition of existing law provided by Section 6. And second, in any event, even if it does, the law under which it was passed, that is to say, Section 105 of the Public Health Ordinance, 1940, to the extent that it authorised such an abridgment or infringement, was inconsistent with Sections 7 to 12 of the Constitution, and so to this extent it was void and could not authorise the relevant regulations by virtue of Section 2 of the Constitution. Thirdly, we say, in answer to the existing law point, in the further alternative, if Section 105 of the Health Ordinance did prima facie authorise the passing of such an inconsistent regulation, it was, we say, inconsistent with Section 1 of the Constitution, which provides that Trinidad and Tobago is to be, and I quote, a sovereign democratic state. As to the third issue, we say that the appellants are entitled to a declaration that Regulation 3 is null and void and of no effect, at least as between themselves and the Attorney General. We say it does not particularly matter what happens to other people, their fate would have to be decided in other proceedings. And we say also, although this is not strictly a matter before you, the consequence of such a declaration would be that the matter should be remitted to the first instance court to decide whether or not, in the circumstances, my clients should be entitled to an award of damages under Section 14 of the Constitution, that is to say, for redress for breach of their constitutional rights by virtue of their arrest and charge. My lords and my lady, I shall be dealing with all the issues I've mentioned above, save one, and that is that Mr. Anand Ram-Logan, Senior Counsel, will be dealing with the argument that Section 105 of the Ordinance is inconsistent with Section 1 of the Constitution. That is to say, he will be dealing with the sovereign democratic state point. My lords, I must apologise for one thing, and that is overnight we sent further material. This consists in part of material which is already referred to in the parties' written cases, but was omitted, and I'm afraid I only noticed that yesterday as I was running through the bundle. In part, it consists of some further material which relates first to the regulations passed under the Ordinance before 1962, and secondly, an emergency powers ordinance passed in 1947. There is a recent case decided by the Court of Appeal, I think late February, in Trinidad, which is also in the bundle. My lord, I won't be referring to much of that, but I will be referring to one or two of the extracts in that bundle.
Can I ask you
Yes.
just to clarify what you're asking us to have in front of us? We've got the original bundle, which is 4,617 pages.
Yes.
We've got a supplemental bundle of 70 pages.
Yes.
We've got two versions of a second supplemental bundle. One of them is 146 pages. The other version of it is 46 pages. And then there's a third supplemental bundle of 168 pages.
My lords, the first supplemental bundle I will be referring to. As to the second supplemental bundle, it should be the one with just 46 pages, not 146
That was
pages.
the replacement. There was one with 146 and there's another one with 46.
Yes.
So we ignore the 146 one and
Yes.
concentrate on the 46, yeah.
And as to the third supplemental bundle, that consists of various coronavirus regulations which are actually referred to in our case, which for some reason didn't get into the bundle. I'm not quite sure how that happened. But they do demonstrate one of the points we want to make, namely the oddity which has arisen in this case, as we say, that at one moment regulations have been happily passed by the Minister of Health under Section 105 of the Public Health Ordinance, then the President decides that she had better do effectively exactly the same thing under Section 7 to 12 of the Constitution. And then when the House of Representatives says, well, that's enough of that, the Minister just does the same thing all over again. So we say that it may be a jury point, but nonetheless we say it does highlight the oddity of what we say is the state's point. And that is what essentially Supplemental Bundle 3 just has, the various coronavirus regulations to which we refer in our case, which make that point good, which I thought you should see, just so you can see the almost exact similarity between the two. And so, my lords, once again, I do apologise for that. I know how irritating it is to get late material, but I hope that I won't have to take you to very much of it, but it is quite important, perhaps for deliberations too, to see what the material is which we refer to in our cases.
Yes, very well.
My lords, if I can first summarise the legislative history of the matter. On the 30th of January 2020, the World Health Organization declared COVID-19 to be a pandemic. And on the following day, the 31st of January, the President of Trinidad and Tobago declared coronavirus to be a dangerous infectious disease. I quote, dangerous infectious disease under Section 103 of the Public Health Ordinance. On the 19th of March 2020, the first coronavirus regulations were passed pursuant to Section 105, creating various offences for breach of those regulations. And on the 20th of March 2020, Parliament increased the fine for breaches of such regulation, which were in the previous Act, or previously existing ordinance, to 50,000 Trinidad and Tobago, 50,000 TT dollars, but it kept the previous sentence of 6 months. The increase in fine was, the fine was later increased at the end of August 2020 to $250,000. On the 9th of April 2020, after a series of further regulations, version 8 was passed, which you can see at 1374, I'll come to that in a minute, which was the relevant version in force in this case when the offences are said to have been committed. And my Lord, if I can ask you to go please to page 1374. Of the electronic bundle, you will see the relevant regulation. (1374), my lords, my lady, and you'll see legal notice number 71, the Public Health Ordinance, Chapter 12, Number 4 regulations, and you'll see the sections under which it is passed, made by the Minister under Section 105 and confirmed by the President under Section 167 of the Ordinance. Regulation 1 says what the regulations are to be called. And then Regulation 2 deals with people in motor cars. And then Regulation 3.1. During the period specified in Regulation 10, a person shall not, without reasonable justification, A, be at any workplace unless, 1, the workplace is associated with a service specified in sub-Regulation 2, the presence of the person at the workplace is essential for the carrying out or provision of a service specified in sub-Regulation 2, and it is not practicable for the person to work from home. And then B, gather in any public place where, 1, the number of persons gathered at any time exceeds 5, and 2, the gathering is not associated with the service specified in sub-Regulation 2. Or B, or C rather, be found at or in any beach, river, stream, or spring, unless the presence of that person is essential for the carrying out or provision of a service specified in sub-Regulation 2. And then subsection 2 goes on to specify a whole series of services, which are those referred to in 3, subsection 1. In other words, the people who can go to a workplace where it's not practicable to work from home, broadly. And you'll see that list continues from subsection 2 on 1374 all the way down. It's essentially public servants who can see, judges, emergency services and so forth, health services on page 1375, essential public services, people working in essential public services on page 1376, and things, and then 1377, financial services and so forth. So there are quite a lot of categories of people who are allowed to work at work as long as it's necessary to do so, essential to do so. And this list goes on a long way, all the way to 1383. And then you get to 1383, subsection 6, which gives the definition of gathering. For the purposes of this regulation, gathering means the congregating or assembly of a group of persons in one area, and services include services provided by any employee. And then there's the provision of a fine in subsection 7 of $50,000. That was the maximum at that time. The length of time for which this regulation was in force is at 1385, Regulation 10. 7th of April to the 30th of April. And that was a recurring feature of these regulations. They would all be in force for a 2-3 week period of time or thereabouts. And sometimes they would be interrupted within that period of time. So, for instance, if one goes to 1386, you can see regulation version number 9, 1386, which interrupted, if I can put it that way, the previous regulation, because it was passed, this regulation was passed, I think I'm right in saying, on the 9th of April 2020. So these regulations were subject to quite a bit of change, although the essence of them remained the same. And in particular, my lords, the essence of Regulation 3 remained the same until it seems May 2021, or perhaps before then, when I will show you what happened to Regulation 3 at that point. My Lord, if I could ask you, please, just to go to the third supplemental bundle, which is at page 168. Sorry, not at page 168. The third supplemental bundle begins at page 1. On the 16th of May, 2021, two things happened. And that is pursuant to a presidential proclamation made on the 15th of May 2021, the President passed emergency powers regulations under Section 7 of the Constitution. These covered much the same ground as the public health or the coronavirus regulations had until then, in particular Regulation 3. And perhaps, my Lord, I asked you to go to the third supplemental bundle. Can I perhaps instead, rather than go to that immediately, ask you please to go to page 1312 at 1314 of the main bundle. 1312 of the main bundle. And you'll see at the top, 1312, regulations made by the President under Section 7 of the Constitution, Emergency Powers Regulations 2021, and you'll see the date at the top, 16th of May 2021. And in the definition section, you'll just see a note on the 1312, period of public emergency, means the period during which the state of public emergency declared by the proclamation exists, including any extensions thereof. And then at page 1314...
That was the proclamation that had been made under the Constitution, not the proclamation
yes.
under the ordinance.
My lady, yes, absolutely right, yes. And that proclamation be made on the 15th of May. We've got it in the bundle, but I'm taking it as read for the moment. So the proclamation 15th of May, and in come the regulations on the 16th of May, and Regulation 3 at 1314. You will see it's very similar, not identical, in the material part to Regulation 3 of the coronavirus regulation. During the period of public emergency, between the hours of 5:01 a.m. and 8:59 p.m. every day, so it's not all day, every day, a person shall not gather in any public place unless the gathering, for the purposes of the services, is specified in sub-regulation 10 and doesn't exceed 5 persons at any time, or be at work unless the services are specified in sub-regulation 10 and shall, where possible, work from home, and then be found on any beach and river and so on and so forth. And then various other things are added. But broadly, this is what is now in the emergency powers regulations. An amended version was passed shortly afterwards, but nothing much turns on it, and that is on the 29th of May, 2021.
In 3.1a,
yes.
Are those two conditions that it has to be for the purposes of the services specified? Is it and or does not succeed 5 persons at a time?
Well, it doesn't say, well, my lady, I don't know, is the answer. We said it doesn't particularly affect the argument. It would appear it should be or if one construes it in light of what had gone before.
Yes, well, the only conjunction is in N, at the end of N, where we have the word or. So you think or runs right the way through?
Well, it would, on the face of it, that's the more natural construction. That's all I can say. More sensible construction. And, my lords, these regulations were placed before Parliament pursuant to the constitutional requirement, which by resolution on the 24th of May 2021 extended the proclamation for 3 months to 25th of August 2021, and then to the for a further 3 months to 25th of November 2021. And you see that 1339, the first resolution, the preamble recites the background to the proclamation and to the fact of the presentation to the House of Representatives. You can see the resolution at the end. Now, therefore, be it resolved that the House take note of the statement by the President under section 9.1, setting out the specific grounds on which the decision to declare the existence of a state of public emergency was based, sorry. And then again, at 1368, a further extension is granted. Which you can see an extension for a further 3 months to the 25th of November. Now, while I'm in this bundle, I may as well just finish off what happened to these regulations. One can then go to 1369, which is...
I'm so sorry, these are an extension of the proclamation as distinct from the regulations themselves, but obviously they'll have an impact on the regulations.
Well, I'm going to come to what happened to the regulations as well.
Fine.
But this is all now under the Constitution. So what I showed you a moment ago and what you see at 1368, these are the resolutions by the House of Representatives, which is effectively the lower house, the elected house, and resolutions by the lower house, the House of Representatives, to extend the proclamation. And that is necessary. I'll come to the proclamation later. That is necessary, a necessary precondition for their continued existence. So you've got 2 extensions of 3 months, basically. However, shortly, and there is power, I should say, to extend further, although that requires both the approval of the House of Representatives and the Senate, which I'll come to later. But you can see on page 1369 the resolution 1369, which revokes the state of emergency. You can see that the preamble sets out what has happened in the past. You can pick it up halfway down. Whereas the President, by proclamation on the 15th of May, declared that a state of public emergency exists in the Republic, and whereas the House of Representatives, by resolution and so forth, and then you have the reference to the extension on the 25th of August, and whereas it is necessary and expedient that the said proclamation should be revoked, now therefore be it resolved that the proclamation made by the President on the 15th of May 2021 declaring that the state of public emergency exists in the Republic of Trinidad and Tobago be revoked with effect from midnight on the 17th of November.
So that was both the extension to November and the revocation?
Yes, and it is what you might call is an early revocation. This is on the 17th of November. It was going to, the proclamation or the effect of the resolution had been to continue the state of emergency to the 25th of November. But they decide on the 17th of November to bring it to an end, as they can. So that's what happens in this 6-month period, and we say that was the right way of going about it. As simple as that. It's important, we say, that under the Constitution, the House of Representatives has a say in the length of time and the nature of the regulations. Now, one asks, well, what happened to the coronavirus regulations in the meantime? And for that, my lords, I'm afraid we do have to go to the third supplemental bundle, which has got the relevant coronavirus regulations in force in this period amongst them. One can pick it up at, I think, page 3 of the supplemental bundle. At page 3, you have a regulation, this now being passed by the Minister, and this was one which he had passed, I think I'm right in saying, on or about the 12th of May, 2021. In other words, just 4 days before the presidential proclamation came in. And if you go to Regulation 3, you can see during the period specified in Regulation 17, persons shall not be at any workplace unless specified in sub-regulation 2, and shall where possible work from home, or B, gather in any public place where the persons therein exceed 5 persons at a time, and shall be associated with those services specified in sub-regulation 2. You'll note that without reasonable justification, which was in the April 2020 regulation, has gone. So it's toughened up, if I can put it that way. And then subsection 2, there's no time limit, I should say, as opposed to in the emergency regulations. And subsection 2 sets out, I think, although I haven't actually analysed them, it seems a very similar set of people as the regulation number 8, the 8th regulation did back in April 2020, for the people who were entitled to work. My Lords, it's not entirely clear, just looking at 3.1, whether the restriction on gathering in a public place is absolute unless it is associated with providing services. But, my Lords, again, that may not matter very much because this was passed after my clients were charged with the relevant offence. But I show you this because this is what the position was as of 12th of May 2021, in other words, mirroring what had been going on previously. But then after that, shortly after that, this, I think I'm right in saying, if one turns to page 18, these regulations were due to expire on the 23rd of May 2021. But then they were interrupted, so to speak, if one goes to page 24, by a new set of coronavirus regulations at page 24. Now, my Lords and my Lady, what you will see in this is the restriction on gatherings and working in certain places is gone. That is because that has now been transferred, if I can put it that way, to the emergency powers regulations, which the President passed on the same day, the 16th of May. And all you find in these regulations is what you might call rather less swinging restrictions, face masks in cars and things like that. It's a much gentler regime. And we say it may well be that these regulations, as passed, did not contravene any fundamental rights, such as gatherings and things. And these regulations continued in this form, more or less in this form, until the 17th of November 2021, that's to say, modified form, until the 17th November 2021. But then, subsequently, when they came back again, on the 17th of November 2021, when the emergency powers regulations came to an end, and when the emergency proclamation came to an end, the Minister got back, so to speak, to his old pattern of passing fairly swinging regulations. And you can see that, my lords, I think I'm right in saying, I've lost the reference, but it's, I think you can pick it up at page 77, which is which is one of the last of the modified versions in October 2021. And again, there's another modified version at page 94, which is version number 21. I think it's number 22, which one sees at page 112. Which now reintroduces, which is passed on the 17th of November, page 112. This is passed on the 17th of November, which now reintroduces what you might call the old pattern. I think I'm right in saying it's this one, my lords. I apologise if it's not. I think it is this one, yes. Page 113, you'll see Regulation 3. The restriction on gatherings, although now the restriction on gatherings is relaxed so that 10 rather than 5 people can meet on a public place. And otherwise, effectively, the minister from this point on takes over, or takes back, the role which he had previously adopted at the beginning. My lords, the current position under the regulations is that there is a regulation in force which prevents gatherings of...
The proclamation that had been made under section 103.
Yes.
Was that still in existence all the way through?
It appears to have been, yes. As far as we can tell, there's no suggestion it was revoked. So in other words, there was the 103 proclamation, which continued all the way through and was used initially for the swinging, as we say, the swinging regulations, then for the modified regulations, and then again it's still being used for the regulations which have come back in since November 2021. As far as the presidential proclamation under the Constitution is concerned, that subsisted, I think I'm right in saying, only from the 15th or 16th of May 2021 to the 16th of November 2021. So there was a period when there were 2 proclamations in force.
And the section 103 proclamation was by whom? I'm just looking at it.
By the
Originally
President.
said, so the governor is turned into the
Yes.
president.
So under the scheme of the ordinance, originally it was the governor, but now it's the president who makes the proclamation. The minister, in the case of dangerous, I emphasise dangerous infectious diseases, makes regulations, but they are brought into effect only by the president himself. I'll come to that in a minute. So in other words, it's the president who's ultimately got control even of the regulations passed under the Public Health Ordinance. And he does so by proclamation. And those regulations will last only for so long as the proclamation continues.
And is that proclamation still in existence? Or?
The one under the Health Ordinance, we believe to be the case, yes. So that's still going. And what we say, just to anticipate on this point about proclamations, what we say is, well, there's a very similar structure, essentially for passing emergency legislation. We have a presidential proclamation, we then have regulations, but it's the president each time who is controlling the position, both under the regulations and the length of time for which the regulations can last in the regulations. And under the Constitution, he controls the initial proclamation, but that can be brought to an end by the House of Representatives. That's the difference. Whereas it can't be brought to an end, the Health Ordinance proclamation can't be brought to an end by the representatives. My Lords, my Lady, that's the chronology of the coronavirus legislation. My Lords, as far as the facts are concerned, I don't think I need to say too much more than that on the 9th of April, the appellants were arrested, and 14th of April they were charged with breach of Regulation 3. And, my Lords, one can see a brief summary of their evidence on the matter at page 203 of the record. And perhaps I can just ask you to look at that, just so you can see what they say at page 103.
This is back in the main bundle, is it?
Back in the main bundle, yes.
Sorry, which page did you say? Is it 103 or 203?
203, my Lord.
Right.
Paragraph 27, this is the judgment of Mr. Justice Budu Singh, and he explains the affidavits that were filed on behalf of the claimants, and I think I'm right in saying other people as well, who gave evidence about how they had been affected by the regulations. Paragraph 28, in particular, the Suraj claimants were gathered at Alicia's guest house, I think it was late in the evening, about 11 o'clock, when the police came into the premises and charged them with breaches of the regulations and put them before the court. And then, paragraph 29, in the affidavits of the 5 claimants, several common aspects are present. They were all aware of the regulations and of the stay-at-home order issued on the 29th of March. They claimed the gathering wasn't a party, no loud music, no lewd behaviour, social distancing. They all observed the police entering the premises at about 11 p.m. After their arrest, they were taken to the police station and charged on the 14th. They all had virtual court hearings based on bail, and they've all suffered humiliation as news reports in the media and social media referred to the incident as COVID-19 partygoers appear in court. And further to this, they've all got their own particulars. My Lords, they give certain points as to how their businesses have been affected, but in particular, in the case of Dominic Suraj, at page 205, he was kept in custody for 5.5 days, where he was kept in a cell, didn't have proper facilities, ventilation, had no previous convictions. And over the page 206, the incident has caused him distress and embarrassment, publicity and so on and so forth. He said he was attending the guest house to do charitable work that hurt his business and so on. And Marlon Hines, there's an explanation of what his business is on page 206. His explanation as to why he founded Alicia's guest house. And then page 207, his complaint is his business has been affected. And then Christopher Wilson, similarly, a description of what he does and the embarrassment he suffered. You'll note the penultimate paragraph on 207, he was put in a cell with 8 other persons in custody for 4 days. Ramjohn, over the page, Colin Ramjohn, at page 208. Again, difficulty in selling his fish, and so on and so forth. And the distress is referred to. Then finally, Bruce Bowen, on page 208, explains that he's a charitable worker, and the nature of his charitable work on 209 in relation to the Venezuelan community. And then he too, you'll note halfway down the page, he says he was kept in custody for 5.5 days without proper facilities. Para 31, the court is not in a position to interrogate or come to any conclusion on the reasons the claimants have advanced for being at the guest house on the night in question. Their evidence is material to this claim only to the extent that the regulations have impacted on them, they having been charged with an offence in gathering of over 5 persons in breach of the regulations. They were charged, and under the regulations, certain of their activities have been affected. The evidence at this stage is to record the impact they assert the regulations have had on them, in particular for bringing them to face the court. It's not for me at this stage to examine their defence. My Lords, that was an approach with which the Court of Appeal agreed. My Lords, what appears to have happened to the proceedings, the criminal proceedings, is that after the proceedings in this case have been instituted, the proceedings were dismissed by the magistrate for want of prosecution. We are told the prosecution has appealed against that, but we do not know what has happened to that appeal. So at the moment, the position is unclear as to what has happened to the criminal proceedings. My lords, my lady, that is referred to in the Court of Appeal's judgment. I don't have the reference to hand, but they note that there was an appeal. I think I'm right in saying by the state, or by the prosecution, but the outcome is not yet known. That was back in July 2021. If I can now go to the first issue, namely, did the regulations prima facie breach the freedoms of movement and of association and assembly? And what I propose to do first is to look at the Constitution.
When you say prima facie in this issue, is that subject to them being saved?
Yes, that's why I say prima
Yes.
facie. I'm perhaps being too pedantic. I could just be. but when I say prima facie, I mean we say there was a breach, but of course the next question is, were they saved in any event? And therefore there was no breach. Strictly speaking, if there are existing laws, there is no breach at all.
Yes, but you're not referring by saying prima facie to the Suraj test, are you?
No.
Okay, just
If I could just intervene, it would seem, in fact, there's a large degree of common ground between myself and my learned friend about Suraj.
Yes.
There may be arguments around the edges, but broadly speaking, those don't seem to be terribly important to the resolution of this case. But I will touch on that later, if I may. So when I say prima facie, was there a prima facie breach, I mean subject to the existing laws point. And we say there was, but I'll deal with the breach point first, then the existing laws point next. And what I propose to do is to look at the Constitution, the 1976 Constitution, and briefly also at the 62 Constitution, and also the Public Health Ordinance, because it's important to see in my submission the width of some of the things it provides for, albeit not on the facts of this case. It's quite swinging. And I will also ask you to look at a short ordinance, which is the Emergency Powers Ordinance, which was passed in 1947.
I'd quite like to understand at some point the confirmation by the President under 167 of the ordinance.
Well, my lady, that is why we have the third supplemental bundle, and I apologise for that, or maybe it's the second supplemental bundle, because Section 167 didn't find its way into the main bundle, but I will show you that. So if I may first go to the Constitution, which one can see at 1279 of the main bundle. It's also in the core bundle at 4408, but whichever is easier. But I will, if I may, for the moment, take it from 1279 of the main bundle. This is the 1976 Constitution, which established Trinidad and Tobago as a republic independent from the Crown. It's in large part, but not totally, identical in material respects to the 1962 Constitution, but I will point out one or two differences in a moment. You will see at 1279, this is the Act which is passed, the statute which is passed, which introduces the Constitution. And what I would ask you to go to now is 1281. And I will ask you to look at, although, my lords, my lady, you may be fairly familiar with this material, I do want to look at the words of the preamble in certain respects and of sections 4 and 5, because they're important to the arguments that will come later. And you'll see the preamble, 1281, whereas the people of Trinidad and Tobago have affirmed that the nation of Trinidad and Tobago is founded upon principles that acknowledge the supremacy of God, faith in fundamental rights, human rights and freedoms, the position of the family in a society of free men, and the dignity of the human person. So right up at the forefront is a reference to the fundamental rights and freedoms. B, there's respect for the principles of social justice. My Lords, I don't think so much turns on that, on the facts of this case. And then C, have asserted their belief in a democratic society in which all persons may, to the extent of their capacity, play some part in the institutions of the national life, and thus develop and maintain respect for lawfully constituted authority. And then D, recognise that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values, and I emphasise, and the rule of law. And then E, desire that their constitution should enshrine the above-mentioned principles and beliefs and make provision for ensuring the protection of the fundamental rights and freedoms. And again, a reference to that, and we say it's important to bear in mind the emphasis this preamble gives when determining what is the scope of the protection given to the fundamental rights and freedoms. That, in many respects, is the issue between myself and my learned friends. And then over the page at 1282, now therefore the following provision shall have effect as the Constitution of the Republic of Trinidad and Tobago. And then section 1, subsection 1, the Republic of Trinidad and Tobago shall be a sovereign democratic state. And then 2, this Constitution is the supreme law of Trinidad and Tobago, and any other law that is inconsistent with this Constitution is void to the extent of the inconsistency. While I'm on these pages, 1283, you'll see the definition of law. Law includes any enactment and any act or statutory instrument of the United Kingdom that before the commencement of this Constitution had effect as part of the law, having the force of law, and any unwritten rule of law. So one has to read the rights and freedoms subject to that. And then moving on, 1286. And words I'll come back to when I'm running my argument, but just for the moment I want to draw them to your Lordship's attention. Section 4, it is hereby recognised and declared that in Trinidad and Tobago there have existed, and these are the really important words, there have existed and shall continue to exist, without discrimination by reason of race, origin, colour, religion or sex, the following fundamental human rights and freedoms, namely, then a series of rights are given from A to F, life and liberty, equality before the law and so forth, respect for family life, equality of treatment, right to join parties, right of the parent to provide for the education of their child. And then G onwards is freedoms. And that's what this case was about. G, freedom of movement. H, freedom of conscience and religious belief and observance. I, freedom of thought and expression. J, freedom of association and assembly. And K, freedom of the press. My Lords, has been observed in many cases, these of course are expressed in very general terms, and so one has to look at, one has to go beyond the mere words to find out what the scope of their protection is. And then section 5, except as is otherwise, and the word we rely on, expressly provided in this chapter and in section 54, no law may abrogate, abridge or infringe, that's one part, or authorise the abrogation, infringement, abridgment or infringement of any of the rights and freedoms hereinbefore recognised and declared. And then subsection 2 goes on to deal with essentially judicial matters or fair trial matters, saying without prejudice to that, but subject to this chapter, Parliament may not authorise arbitrary detention and so forth. But I think what one sees from A down to G is almost exclusively dealing with legal proceedings of one sort or another. So there's a specific prohibition in relation to legal proceedings, but then you get to H, which is more general, deprive a person of the right to such procedural provisions as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. So, my Lord, that's, we say, what you might call the governing part of Chapter 1. You then have exceptions set out in Chapter 1. And again, if I may just take them broadly for the moment, the first exception is for existing law, Section 6. And my Lords, my Lady, you will no doubt be familiar with this section, but that's the first exception, existing law. That, of course, is another issue in the case which I'll have to address. The second exception And we say a very important exception on the facts of this case is exceptions for emergencies. Section 7.1, without prejudice to the power of Parliament to make provision in the premise, but subject to this section, where any period of public emergency exists, the President may, due regard being had to the circumstances of any situation likely to arise or to exist, during such period, make regulations, and that's what he did here, for the purpose of dealing with that situation, and issue orders and instructions for the purpose of the exercise of any powers conferred on him or any other person by any act referred to in subsection 3 or instrument made under this section. Subsection 2 provides for power of detention. That doesn't arise in this case, but subsection 3, an act that is passed during a period of public emergency and is expressly declared to have effect only during that period, or any regulations made under subsection 1, shall have effect even though it's inconsistent with sections 4 and 5, except insofar as its provisions may be shown not to be reasonably justifiable for the purpose of dealing with the situation that exists during that period. So there's two ways one can go about it. First of all, the President can make his proclamation, and he can make regulations. That's subsection 1. And subsection 3 is envisaging another way of dealing with an emergency, which is Parliament itself passing an act, as long as its provisions are reasonably justifiable, or actually the other way around, as long as they're not unreasonably justifiable. And then section 8, subject to this section, for the purposes of this chapter, the President may, from time to time, make a proclamation declaring that a state of public emergency exists. A proclamation shall not be made under subsection 1, made under subsection 1, shall not be effective unless it contains a declaration that the President is satisfied, A, that a public emergency has arisen as a result of the imminence of a state of war, B, and this is the important one, that a public emergency has arisen as a result of the occurrence of any earthquake, hurricane, flood, fire, outbreak of pestilence or of infectious disease. Those are the important words. Outbreak of pestilence or of infectious disease, or other calamity, whether similar to the foregoing or not, or C, that action has been taken or was immediately threatened by any person of such nature or on such an extensive scale as to be likely to endanger the public safety or to deprive the community or any substantial portion of the community of supplies and services. So in other words, essentially, a state of external war is A, B is basically any other type of public emergency, including pestilence and infectious disease, and then C is essentially internal dissension or internal strife. It would seem, at least. Then section 9, within 3 days of the making of the proclamation, the President shall deliver to the Speaker for presentation to the House of Representatives a statement setting out the specific grounds on which the decision to declare the existence of a state of public emergency was based. And a date shall be fixed for a debate on this statement as soon as practicable, but in any event not later than 15 days from the date of the proclamation. 2, a proclamation made by the President for the purposes of and in accordance with Section 8 shall, unless previously revoked, remain in force for 15 days. So, in other words, the President's got to get his proclamation before the House of Representatives pretty quickly. And then Section 10, before its expiration, the proclamation may be extended from time to time by resolution supported by a simple majority vote of the House of Representatives. So, however, that no extension exceeds 3 months, and the extensions do not in the aggregate exceed 6 months. That's what happened here, more or less. 2, the proclamation may be further extended from time to time for not more than 3 months at any one time by a resolution passed by both Houses of Parliament and supported by the votes of not less than 3/5 of all the members of each House. So, in other words, if you want to go beyond 6 months, you've got to get both Houses approving. And then 3, the proclamation may be revoked at any time by a resolution supported by a simple majority vote of the House of Representatives. So, in other words, the way this scheme works is, it is, or I might say, it is slightly loaded in favour of the proclamation lasting only 6 months, unless it really is shown that it can pass, unless both houses say it can carry on. And then 4, in this period, a period of public emergency means any period during which Trinidad is at war, B, there is in force a proclamation by the President declaring that a state of public emergency exists, or there is in force a resolution of both Houses of Parliament, supported by the votes of not less than 2/3 of all the members of each House, declaring that democratic institutions in Trinidad and Tobago are threatened by subversion. Section 11 then deals with detention. I don't think I need to take you to that. Detention, that is pursuant to the emergency powers, or regulations passed under the emergency powers. And then section 12 deals with the problem which might arise if there's not enough time to make a proclamation in the Gazette and to make it public. The President can essentially arrange for notices to be put up in public places and so forth. Section 13, now this is the third exception, exceptions for certain legislation. And again, my lords, we say this is an important part of the case. An act to which this section applies may expressly declare that it shall have effect even though inconsistent with sections 4 and 5, and if any such act does so declare, it shall have effect accordingly unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. And then 2, an act to which this section applies is one, the bill for which has been passed by both houses, and that the final vote thereon in each house has been supported by the votes of not less than 3/5 of all the members of that house. So it's quite a stringent provision, 3/5 of all, not just those who turn up for the day, but all members. And then for the purpose of subsection 2, there's a provision about how you calculate the numbers, which is immaterial for the moment. And what we say is important about this section is that this is a specific way, this provides for a specific way of passing infringing legislation. And also, even then, that infringing legislation has to satisfy the test, or rather, has to satisfy an attack that it is against it, that it's not reasonably justifiable in a society with respect for rights and freedoms. And then section 14, this is obviously not one of the exceptions, but this is the relief section. This provides...
Just on section 30,
yes.
are you going to assist us at some stage with submissions about how that interacts with the Surat?
Well, yes, I was going to in our case, but as it seems that there's pretty well common ground between my learned friend and myself, that I certainly can, but I wasn't going to do so in such detail because it seems there is a degree of common ground that Surat does not say that any ordinary legislation ordinary legislation can infringe fundamental rights and freedoms as long as it is proportionate, even if it infringes them to a considerable extent. As I understand my learned friend, he agrees that that ordinary legislation can make alterations up to a certain level of significance, I think is the way Lord Dyson put it in one of the cases. Ordinary legislation can make alterations or have an impact on the fundamental rights and freedoms to a certain level of significance, is the phrase that's used. If it does that, then there's nothing wrong with it. So in other words, ordinary legislation can make some difference to the existing rights and freedoms. But he does not go so far as to say that ordinary legislation can altogether abrogate the fundamental rights and freedoms just because it is serving a legitimate aim.
Well, there's a big gulf between abrogation on the one hand and having a limited effect, and one of the words used in the Constitution is a bridge.
Yes.
And I think I wouldn't encourage you to rush over the case of Surat.
My lords, in that case,
I'd be very interested to hear your submissions on it.
well, my lords, I am prepared to deal with that, obviously.
But the fact that there may be a measure of agreement, I don't think should be determinative on how we look at this.
Yeah,
Unless the respondent agrees that this legislation went further and does amount to an abridgment or an abrogation, and they rely solely on the saving provision. But I think if there's a disagreement as to whether this legislation went further than Surat and does then amount to an abridgment, then I think we would like to.
I shall be dealing with that. If I can just anticipate, I understand my learned friend's main point now to be that the scope of the fundamental rights and freedoms has to be assessed by reference to the position as it stood at 1962 and 1976, with all the qualifications that then existed or could be imposed, including, therefore, the qualifications which you see in section 103 of the Public Health Ordinance. You take that, so to speak, to be as part of the background of the scope of the fundamental rights and freedoms. It is subject to all qualifications then in existence. Our position is it is subject indeed to the normal, traditional qualifications, that, let's say, freedom of expression is subject to defamation. The normal, traditional qualifications, of course it's subject to the normal, traditional qualifications, but we say the protection for fundamental rights and freedoms is definitely not subject to the particular special restrictions which could, from time to time, have been imposed by the emergency legislation in force, as at 1961 or 1962 or as at 1976. So in other words, we draw that distinction. We accept there are qualifications, but they are the traditional, normal common law, or maybe sometimes long-standing statutory qualifications, like religious worship, for instance, but it is not subject to qualifications imposed by emergency legislation. We say, first of all, that follows from the words of the Constitution, but secondly, we say, if they aren't subject to the existing qualifications imposed by section 105 of the Ordinance, and indeed by the Emergency Powers Ordinance, sections 7 to 12 are a dead end. There's just no point. So that we say, it appears, as I read my learned friend's case, we say that's the bone of contention between us.
I may have got the wrong end of the stick. I thought he had an alternative case that these are limited rights
yes.
set out in the Constitution, and that the interference with those rights achieved by the regulations was proportionate to a legitimate aim, therefore no infringement or breach of the fundamental right.
Well, my lord, I'll be dealing with that. I hadn't understood that to be his main point, but I will be dealing with that point, to which we say that's not the right approach to the Constitution. We simply say if that approach is being adopted, that is wrong. We say the question is simply, was there an infringement or an abridgment? And if the answer to that is yes, that's the end of it.
But forgive me, as I understood it, I might have got the wrong end.
Yes.
So it's to that point that the point about the limited nature of the rights and whether this interference is proportionate to a legitimate aim goes, because if they are limited rights and this is merely a proportionate interference, therefore no breach of the rights, there is no abridgment of the right.
We say that, although in the case of these rights minor breaches could be justifiable, we are not here talking about minor breaches.
But why do you restrict it in relation to minor breaches? Why, if they're limited rights,
yes.
Why can't any interference with the right be justified in the ordinary way, so that at the end of the day, even if it might be quite a big interference, if there's a big legitimate interest that is being protected, so that it can be said the interference with the right is proportionate, yes. Therefore no breach of the right, why can't one just say, and therefore no abridgment of the right?
Well, my lords, we say that's not we say it's because the right can be abridged or abrogated, abridged or infringed only by the express ways set out in the Constitution.
Right.
That is by the existing laws provision, alternatively by the presidential powers, emergency powers provisions, alternatively by the Section 13 special statute.
Right. I follow that, but what I'm putting into you
yes,
is on this argument, if it's right, there is no infringement or abrogation of the right.
Well, my lords, we simply say their argument on that is wrong. It is not right to say that the Constitution does not authorise ordinary legislation which does anything more than make minor adjustments, regardless of proportionality. In other words, it does not authorise a big adjustment which can be justified by a legitimate aim. That has
So,
to
for
be done.
example, the law of defamation,
Yes.
does that have to be backed up by a presidential proclamation or something of the kind?
Oh, no, my lords, no. But what we do say, I mean, for instance, that's exactly what we say. We say minor alterations.
Well, that's not a minor. But what about extradition? That's a major interference with somebody's Article 8 rights, or imprisonment.
Yes.
A major interference.
Well, my lord, it all depends how great the interference is. If the interference, our position is this, if the interference is minimal or along the lines which existed, or of the type which existed as at 1962 or 1976, if the interference is limited and of that type which was in existence in 62 or 76, then we say it does not require special legislation. If, however, the interference is substantial, then it does require special legislation.
So, I mean, originalism seems to be common ground. On your approach, we have to go back to 1962 to work out what sort of interference would be regarded as minor.
Well, I'm not saying that exactly, my lord. I say you go back to 1962 to work out what the state of play was as of 1962. And my lord's going to give a concrete example, for example, the law of defamation. The freedom of expression in 1962 was subject to the law of defamation. That's clear. Now, we do not say that any alteration to the law of defamation thereafter had to be passed by special legislation. We accept, for instance, as in Pandey, one of the cases which is referred to, I think, in both of our cases, that the common law can develop to include perhaps certain further offences for publication. In other words, certain further
Might adopt a Reynolds test, for example.
Yes, the Reynolds test, exactly. And we accept that. And we say the Constitution does allow for ordinary legislation which makes adjustments, minor adjustments of the sort, which anyone would say they don't go too far, and they don't make major alterations to the state the law was in, as at 1962 or 76.
It is that I'm struggling with, this idea, this agreement between the parties on a state of originalism, because it's well established in the board's jurisprudence that constitutions are living instruments and that that fundamental rights and freedoms laid down in Constitution, for example, Section 4C, the right of an individual to respect for his private and family life, may develop over time.
Yes.
So how on earth are you going to go back to 1962 and say, well, what's the situation then, and has there been a minor adjustment or from that? That's why I think you do have to face up to the Suraj jurisprudence and try to persuade us that the majority in Suraj were wrong to measure wrong to take a proportionality assessment of ordinary legislation and its impact on existing rights.
Well, my lord, may I perhaps do that? I've debated the point with you now. I'm happy. Can I come back to that, if I may?
If you want, but,
Sorry, yes.
but it's a matter of considerable importance in this appeal, I would suggest.
I'm wondering whether it's helpful to refer to these adjustments as minor or major, because as my Lord Reid says, there are some what you've called ordinary restrictions which all sovereign democratic nations have, which are ordinary, even though they're very important, particularly for the person concerned. And I think there are difficulties with this going back to 1962, but I'm not sure that you need to do that in order to show or argue that the existence of the enhanced provisions in sections 7 to 12 and section 13 have an impact on what degree of proportionality test you're applying at the infringement stage.
Well, my lady, you anticipate one of our, perhaps our main argument, that the existence of Section 7 to 12 simply provides for emergency situations. That being the case, you can, in that say, they provide for special situations in which infringing legislation can be passed, whether by Parliament or by proclamation and regulations. That's what it provides for. We say Section 7 to 12, having expressly provided for this type of event, what you might call special emergency legislation, you cannot say that the same thing could still be done by ordinary legislation. And secondly, the scope of the fundamental rights and freedoms is not intended to be qualified by the fact that in the past there had always been emergency legislation powers, even before the 1962 Constitution. You simply say to yourself, is this, adopting your ladyship's word, ordinary, is this type of legislation something which happens in the ordinary course of events and is intended, I might add, to be permanent? Or is this legislation a temporary piece of legislation to deal with an emergency? And the fundamental rights and freedoms are not intended to be interpreted in such a way that they can be, effectively, you can remove them by emergency legislation, even if it's just ordinary legislation. So in other words, supposing what had happened here, let's say there had never been a public health ordinance, and let's say in the summer of 2020, Parliament had passed an act by ordinary legislation imposing all the restrictions which one sees in the coronavirus regulations, and in particular the limit of 5 people gathering in a public place and so forth. We would be saying, no, you could do that only by either A, the special emergency powers, which provide for that type of legislation, or B, by Section 13, which provides for a 3/5 majority in both houses.
If one reflects for a moment on the history, Trinidad was at one time subject to the ECHR, and at that time there would have been a similar catalogue of rights to the one we see now in Section 4, but there would have been a power to derogate from those rights in an emergency situation. And that would be essential because, and the reason why the ECHR has that power is because some of the rights which it guarantees are unqualified. And so, for example, the right to, or the rights relating to detention.
Yes.
So you couldn't detain people without trial under the ECHR unless there was a power, unless you derogated from Article 5 in an emergency. If the emergency, for example, was such that internment was thought to be appropriate.
Yes.
Now, thinking about that in the context of the Constitution, which Trinidad now has instead, we have rights similar to the ECHR rights in Section 4, which might be applied in a similar way to the articles of the ECHR. We have a power, we have sections to deal with emergencies, but rather than derogate from the rights in any absolute kind of a way, they substitute a different test of whether the emergency measure is, I forget the exact wording, but reasonably justifiable
yes.
in a democratic society, something of that kind.
Yes.
So it's a qualified derogation, one might say.
So qualified, I missed
A
that.
derogation.
Yes. Yes. But you have my essential position, which I hope I've made plain by the example I've just given of supposing a statute had been passed in May 2020, doing what the coronavirus regulations do. We would say it can't be done. That type of departure or infringement, we would say alteration, infringement, limitation, is provided for expressly by different means in the Constitution itself. It's a sort of De Keyser point, if there's one way, if there are two different ways of doing something, one is it gives what you might call the executive a wide power to do something, and then a statute or constitution comes along and says, well, if you want to do that, you've got to go through the following hoops. Then, by necessary implication, you've got an inconsistency between the two, and you've got to follow the more restrictive way of doing things. It's very much, and really, my lords, if you ask me, can't Mr. Knox get on with it, what's your best point? I would simply say it is section 7 to 12. That's the real difficulty for the state, we say.
I'm just pursuing what my lord was putting to you. I'm looking at section 7.2.
Yes.
That specifically says that it is possible under the emergency powers legislation, which means either act or regulations, to make provision for detention of persons.
Yes.
So you can do more things under section 7 than you would be able to do under ordinary legislation.
Yes.
Apart from section 7. So I'm not, and I mean, one could imagine other forms of emergency which don't fall precisely within the forms of emergency which are addressed in section 7 itself, where the state would just have to rely on ordinary legislation. So putting those two things together, I'm not sure at the moment, but you're going to assist us further as to why section 7 is an exclusive procedure which excludes the possibility of ordinary regulations or legislation dealing with matters which might fall within the scope of section 7, but about which there might be argument. I mean, there might be argument about whether there is a sufficiency of one of the matters within section 8.2 as to justify the President in making a proclamation. So in other words, that there might be difficulties with being absolutely sure where the boundaries of the regime in section 7 arise.
Well, my lord, there might be. Can I just say for the moment what my short answer and anticipated is? We say it goes back to section 5, 1267. And we say, section 5.1, except as is otherwise expressly provided in this chapter, and in section 54, which is a section which provides for how you can change this part of the Constitution, no law may abrogate, and so on and so forth, or authorise. So we say section 5 is saying that you've got to find the only way you can abrogate is by the ways expressly set out. Right. In sections 7 to...
But that's the point of the Suraj argument, that you don't get into that.
Well, that's why we say Suraj is wrong, save to the very limited extent which we've set out in our case. If it says anything like what the Court of Appeal thought it said, we say it's wrong.
Right.
We do it.
Can I just ask,
yes.
because it's the point troubling me, where do you get your distinction between minor adjustments and major adjustments in the rights, in the operation of the rights?
Well, my lord, minor and maybe ordinary as opposed to extraordinary. I get that, my lords, from the proposition that one does not adopt an absolutist position in deciding whether there's been an infringement. Let us take the law of defamation, for example. One could take an absolute position and say, well, all this stuff about qualified privilege is derogating from the freedom of expression, and so forth. One could find all sorts of examples where one might say there has been a slight interference with the fundamental rights and freedoms, but it's a perfectly sensible and common one, which one finds, which is commonplace across the common law world. And in those circumstances, we don't urge upon the board that even in those circumstances, the right can be, we don't say, if that is the scope of the infringement or limitation, we don't say in those circumstances that you need special legislation.
So is the distinction you're drawing, I think when I put to you mine against major, you said yes. Ordinary against extraordinary.
I think I prefer that. Yes, right. My lord. So I think that's a better way of putting it, my lord.
Right.
Yes.
All right. So where do you get the criteria for what counts as extraordinary and therefore illegitimate?
Well, My Lord, it's a fair question, but I would submit, as is so often the case, it's a matter of degree and a matter for the court to decide. One could imagine, no doubt, some cases where it might seem it's very difficult to tell, but other cases, and we say this is an example, the type of qualification that's being introduced here, that is, you can't just go around and see your friends on a gathering of 6 people in a public place. That is extraordinary by any measure. And the other point I would add is this is being introduced by extraordinary legislation. Even under the health ordinance, it's a temporary proclamation to deal with a particular position.
Okay, so, just to pursue this a little bit, it might be said that one of the attractive features of Lady Hale's approach in paragraph 58 of Surat is that it aligns the approach to the fundamental rights here with the general approach to fundamental rights in rights instruments around the world.
Yes.
That it is possible to justify an interference if you have a measure as a proportionate means towards a legitimate aim. And that's a test that applies across the board. You don't have to ask more than that. Obviously, it's quite difficult to apply the test sometimes, but you look very precisely at the particular circumstances, whereas you seem to be introducing a sort of additional set of criteria that you're happy that that's the approach, but only insofar as it's an ordinary interference with the right.
My Lord, I think what we say in our case is trivial, but let's say ordinary and minor interference with the right.
Right.
A minor interference with the right of the sort which is commonplace across the common law world.
So what I'm putting to you, and you'll come to it in due course, is it might be said to be unattractive to introduce such a vague additional criterion on top of the fairly standard approach that Lady Hale seems to adopt in Surat. But you're going to explain to us why.
I will. My Lord, can I just say in a word, there's one difference between the Trinidadian Constitution and, as far as I'm aware, that I stand to be corrected, the human rights, the ECHR, and indeed all the other Caribbean constitutions. Not sure if you find it anywhere else in the world, and that is Section 13.
Right.
And we say Section 13 is obviously envisaging. In a word, my Lord, I take your Lordship's point, but we say the answer to the Surat point is, well, what's Section 13 doing? Very little in real life. If Parliament can say, well, it's legitimate and proportionate, let's do it by ordinary legislation, I've got a 51% majority, oh, don't let's worry about that Section 13 business, we're getting 3/5 of both houses on board, we'll never do that.
Well, I wonder whether it might be said that if you go through the Section 13 procedure, you have a particularly strong statement of the public interest side of the proportionality balance, and that has to be factored then into the way in which proportionality operates at that stage. In other words, if I can put it this way, it's a rather crude way of putting it, the dice are loaded more strongly in favour of the state if they've gone through a Section 13 approach in relation to the fair balance which ordinarily underlies the proportionality test.
Yes.
One, again, slightly rough analogy I've got in my mind is the immigration legislation in this country where, under the regime that was introduced, I think in 2014, statements were introduced in legislation about how the court should approach the public interest side of the balancing test to be applied when proportionality has to be applied in relation to Article 8.
Yes.
Now, it's not a perfect analogy because that's just ordinary legislation. But I just wonder whether under Section 13, since you're pressing us on that, whether it might not be said that, well, if you've got legislation from Parliament with the supermajority in both houses, if you like, supercharges the public interest side of the proportionality balance.
Well, my Lord, obviously I would accept it obviously would, but we say that's not the reason for Section 13. The reason for Section 13 is you can't pass legislation which of an extraordinary type or which materially limits or infringes fundamental rights and freedoms, saved by Section 13. My Lord, can I mention the other point? Just a matter of language. I do submit that if the words abrogate, abridge and infringe are important. A mere, what you might call it, they do suggest something material, something big, if I can put it that way, rather than something unusual. and we would say those words themselves suggest that a relatively minor restriction or limitation should not be regarded as an infringement. My Lords, I will come to this, but Lord Dyson in Papanet said, not talking about legislation, but I think he may have been talking about delegated legislation. But he said, of course, there has any interference with your right to enjoyment of property has to reach a certain level of significance, that's his phrase, for it to be actionable as a breach. And we say that is the distinction. And so, my Lord, I entirely understand your Lordship's point. Well, you know, how does one assess all this? To which we say, well, this is a commonplace in constitutions that it may not be entirely. There may be grey areas.
If I might say so, you seem to be introducing another distinction of what is minor or what is serious. So far, we seem to have had two possibilities. You seemed at one point to be saying, well, you preferred ordinary, extraordinary.
Yes.
But now you're talking about minor and serious. Those two don't map onto each other.
Well, minor and serious may not, I agree, but minor as opposed to major. But, my Lords, I'll have to come to this. I'm doing the best I can with the authorities we've got.
Of course.
And I'm simply trying to explain, and you may say not very well, but I do hope I'm getting across the point. There is broadly, one does understand, and it's not an unintelligible distinction to talk about the difference between ordinary legislation, which does the sort of things which legislation has traditionally done, and extraordinary legislation, which does things which legislation does not normally do, save in various exceptional circumstances. And so, my Lord, that's
Methodologically, you're asking us to adopt a completely different approach from the traditional approach to allegations of breaches of human rights. I mean, normally, the analysis focuses on the purpose of the measure in question and its proportionality to achieve that purpose. And you're asking us, well, you've got two alternative approaches. One is to do with the scale, apparently, of the infringement or gravity of the, because you recognise that these are qualified rights.
yes.
So you're saying, on one approach, that Section 5 is concerned with the scale of the infringement or gravity of the infringement, which I don't quite know. I mean, it sounds rather like the Lord Chancellor's foot. I mean, how one measures that. The other is some sort of survey of jurisprudence around a common law world, and you know. There are some things that are taken for granted throughout the common law world, but there are others where countries differ. Defamation, for example, the freedom of the press, the American system would take a much more defensive view of press freedom than our own would. And if we're talking about religious freedom, religious observation, well, we've only just handed down judgment in two cases to do with same-sex marriage,
Yes.
where we took a view about the position in the Caribbean, which was certainly different from the view that would be taken in Canada or United States or Australia or this country.
Yes. Well, my Lords, I accept that. But I'm conscious of the time. But my short answer at the moment is this is a different constitution from other constitutions in the Caribbean. Section 13 is important in assessing what type of legislation, or rather, what type of legislation can be passed with an ordinary majority, as against what type of legislation can be passed only with a supermajority. And one has to give effect to the obvious intention, I would submit, of the framers of the Constitution, that there is there are some things which ordinary legislation cannot do and can only be done by special majorities, and even then only if it is reasonably justifiable in a society which has respect for fundamental rights and freedoms. And so, my Lords, if I can put it this way, the criticisms or the questions being asked of me and saying, well, why shouldn't it be just like what is normally understood under, for instance, the ECHR and so on and so forth? To which my answer is, you've got a different scheme here from that which applies in the ECHR. There's no equivalent to Section 13 in the Human Rights Act or in the ECHR. And so that's, but I'll obviously have to come back to that. But if I could just move on for a moment. My Lord, my Lady, can I just ask you briefly to look at the 1962 Constitution, because you'll see, as I say, that the 1976 Constitution is obviously trying to firm up in favour of fundamental rights, as against the 1962 Constitution. And the 1962 Constitution is in the second supplementary bundle at page 9. Begins at page 8. And I can take it for the moment from page 9. I think I'm right in saying the preamble is almost exactly the same, but chapter 1, you will see it's hereby recognised and declared that they have existed and shall continue to exist in the same terms as section 4, materially the same terms. Section 2, subject to 3, 4 and 5, no law shall abrogate, abridge or infringe any of the rights hereinbefore recognised. Just one point to note, section 5 of the 76 Constitution adds in save as expressly provided. So section 5 is essentially limiting in a way which the 1962 Constitution did not limit the ways in which alterations could be made.
And just pausing there.
Yes.
I think this is at a time when the ECHR is applicable in relation to Trinidad and Tobago.
Well, my lords, only in the sense that, Trinidad and Tobago at this point is part of is still under the Crown's, it's still, strictly speaking, under the Crown. My lord, whether in fact anyone ever took the point at the time is another matter, but I accept that technically it might be said, by treaty at least, to have been subject to that. Yes.
I think there was a positive extension,
Yes.
wasn't there, to Trinidad and Tobago as to all colonies under Article 56 of the ECHR as it then was.
Right.
Yes.
I'm not raising this for interesting archaeological reasons. The point of making that point is to suggest to you that when one then has the list of the rights set out here,
Yes.
one might expect that they're rights of a kind which were applicable in relation to Trinidad and Tobago under the ECHR, hence qualified, but qualified in the way recognised by Lady Hale in Suraj paragraph 58.
Well, my lords, I would respectfully doubt that. Certainly the authorities, certainly there's a series of cases in which Lord Diplock opined on these provisions, and he says what you do is you look at the law and the settled practice of Trinidad and Tobago as at the day before, so the 31st of August, as it were, 1962, and there's no suggestion in any of his decisions that one should also interpret the fundamental rights and freedoms in the light of the ECHR.
Yes, I mean, the Court of Appeal in this case looked at Hines, looked what Lord Diplock had said there, and took the view that it was inconsistent with what was said in Suraj.
Yes.
That's why I think it's rather important that we...
Yes.
It's probably the most important point in this appeal. We get to the bottom of Suraj.
Yes. Well,
And if I might add to that,
Yes.
I mean, there's a lot of later jurisprudence which does seek to align these. I mean, this is one of the colonial constitutions.
Yes.
With the ECHR, not least Fisher. And
Yes.
A case called Rodriguez.
Yes. Well,
I mean, it might be a good idea actually to have a look at the two judgments that my lord referred to, because we touch upon some of these issues.
yes.
Sorry, so they were handed down last week. One's called Day and Attorney General of the Cayman Islands. The other is Ferguson and Attorney General of Bermuda.
Also, one has to bear in mind at the time when Lord Diplock was writing, there was scarcely any case law from Strasbourg. Whereas by the time Lord Bingham, for example, is writing in cases where he talked about the relationship with the ECHR, there's a great deal of relevant case law.
Yes. Well, my lord, perhaps I can regroup over lunch on that particular point. Anyway, I was just making the point that there's, just by comparison with Section 2, Section 5 has added in save as expressly provided, and we say that matters. If I say save as expressly, that means this is the only way out. You don't see that in this 1962 version. My lord, my lady, you'll see Section 4 is the equivalent of Section 13. So Trinidad has had Section 4 as part of its constitution since Section 13 since 1962. And then you have the emergency powers, equivalent emergency powers provisions in Section 5, and then also Section 8. Section 5 is the essential emergency powers provision. It's got the 3/5 point. Section 6 is essentially the redress point, but then you go back to the emergency powers point.
Sorry, isn't Section 4 the emergency powers?
Yes.
Section 5 equivalent.
Sorry, Section 4 the emergency powers, forgive me.
Section 8 is the public.
Yes.
Yeah.
Well, Section 5 is the Section 13, forgive me. An Act of Parliament may declare it shall have effect notwithstanding Sections 1 and 2, and then it goes on to say you've got to get your 3/5 majority in subsection 2, 5 subsection 2. So that's the equivalent of Section 13.
I mean, again, if we're looking at this through an ECHR prism,
Yes.
which presumably it was being looked at the time,
Yeah.
because there was a concern to ensure that the constitutions of the colonies would be in line with the UK's obligations in public international law under the ECHR.
Yes.
Doesn't Section 5 have the flavour, well, as my lord was putting to you, of it being a form of qualified derogation from the ordinary rights in the way that one has a derogation power under the ECHR?
Oh, certainly. But our point is that it's tougher in Trinidad than it is under the ECHR, because in the ECHR, or now under the Human Rights Act, you just need 51% of an ordinary vote. Here, you're getting the same idea, but in Trinidad, they're tightening it up and saying, no, you need 3/5 if you're going to derogate.
Right, I follow that, but the point of my question anyway is to suggest that the fact that you have a qualified derogation power like Section 5 here or Section 13 in the 1976 Constitution doesn't necessarily mean that one doesn't have ordinary application of the usual proportionality justification test in relation to the rights which exist within the instrument, which is effectively what Lady Hale said in Suraj.
My lord, I understand your lordship's point. If I may come back to it, because I can see it's obviously troubling the board, and I will have to deal with it. But perhaps I just wanted to make another point about the emergency powers in this. Section 7 deals with detention, and then Section 8 provides for the period of public emergency, which is in similar terms to the 76 Constitution. But you will see, and then...
I think Section 7 is actually quite interesting, because there it's clearly adding to the ordinary requirement of an independent and impartial tribunal established by law, and saying, well, here it has to be presided over by a person appointed by the Chief Justice.
Yes.
From amongst people entitled to practice. So that's an additional requirement which one doesn't find in the ECHR, which is obviously bespoke to what the state that Trinidad and Tobago thought it was in 1962, what it needed to do to ensure these rights would be protected.
Yes.
It's
going further.
I just wonder, is it not rather similar to Article 5.4 of the Convention? It is guaranteeing a right of review of detention at regular periods.
Yes, but it's specifying who has to preside over the tribunal.
Yes, whereas Strasbourg, most of the convention simply refers to an independent,
Yeah.
simply require an independent and impartial tribunal.
My Lords, the only point I just want to draw attention to is Section 8 has got a similar provision for period of emergency, but under 8.3 and 8.4, that provided for 6 months. 6 months, as opposed to 3 months. By members of the House of Representatives. But we say that the evident intention of the 1976 Constitution was to firm up on these rights, and if I may, by reference to Lord Sales's point, we say to give further protection than given by the ECHR. Can I go now to the 19...
Well, I'm so sorry, but just on that, they don't seem to have firmed up the rights themselves, or indeed the basic structure, which becomes Section 13 and Section 7.
My Lord, what I meant by that was Section 5 saying save as expressly provided. We say, as opposed to, in other words, you can't imply some sort of rights. It's really got to be there. It's only what you see in black and white.
Sorry, I think that may just be the confusion you had about what Section 5 in the 62 Constitution marries up with. Your Section 5 marries up with Section 13, and it does say may expressly declare.
Ah, but it doesn't say save as expressly provided.
Oh, I see. I'm so sorry. Right.
Forgive me, my Lord, I didn't make that plain. So Section 5 has what you might call a tightening up. It's getting rid of implications. We say, that's the point. Can I go now to the health ordinance itself? I do want to show you one or two parts of it.
I'm so sorry to
Yes.
take up time on this, but which provision in the 1962 Constitution corresponds with Section 5 of the 1976 Constitution, do you say?
Section 5 is the equivalent to Section 13.
No, other way round. What's the equivalent in the 1962 Constitution to what becomes Section 5 in the 1976 Constitution?
Section 2.
Section
2. Section 2.
2.1 looks like Section 6 for the purpose of law in force.
No.
Oh, I'm so sorry.
Article 2, Section 2 of the Constitution, on page 9.
Ah. Oh, sorry.
Effectively 2.
Yep, I've got it. I'm so sorry. I'm being slow here.
4 and 5 in 1976 are effectively both contained in Section 2.
Yes. Yes, thank you very much.
My Lords, the Public Health Ordinance is at 1307 of the main one.
This is main bundle.
Of the main bundle, yes.
7.
My Lords, my Lady, this was passed in 1940 when, as I understand it, Mr. Ram Logan will confirm, when Trinidad was, there was a legislative council, and just a unicameral system. And importantly, my Lord, one point I do want to emphasise is that the regulations for which this provides are not subject to affirmative or negative resolution, because regulations passed before 1962, as I understand it, just weren't. There was, as were, no House of Representatives to go and get the resolution from. Nowadays, regulations, depending on the statute, are subject to negative or affirmative resolution.
I mean, regulations made under recently conferred powers are the powers tend to be subject to some level of parliamentary scrutiny.
Yes, but this one isn't at all, because it's passed in 1940, so there's no parliamentary scrutiny. And if I may, to start in 103, page 1307, the Governor may, by proclamation, I emphasise by proclamation, declare any disease, in addition to the diseases specifically mentioned in section 2 of this ordinance, to be an infectious disease or dangerous infectious disease within the meaning of this ordinance. And so long as the proclamation remains unrevoked, the disease specified therein shall be deemed to be an infectious disease or a dangerous infectious disease, as the case may be. So again, this is providing, we say, that this is a special situation. It's a proclamation. You can pass regulations, but this will only last for so long as the proclamation lasts. And then section 104, my lords, deals with just diseases, not infectious diseases, and it provides for the Governor to have power to provide for hospitals in Trinidad and to spend money from public funds for that purpose. That's just generally diseases. And then section 105 is the relevant section. The board shall have the direction of all measures dealing with dangerous infectious diseases and may make regulations with regard to the control of any dangerous infectious disease for all and any of the following purposes. And then A, this is the relevant regulation as far as the coronavirus regulations go, relevant provision. The restraint, segregation and isolation of persons suffering from any dangerous infectious disease or likely from exposure to infection not to suffer from any such disease. And as we understand it, the way, what is said is that as everyone in the coronavirus pandemic is likely to suffer from exposure to infection, suffer from any such disease, therefore the regulation could be passed, the one that we see. My lords, no challenge was made to the varies or otherwise of the regulations and whether they fell within Regulation A. But, my lords, we do say at the very least this: there is no express provision in this statute saying you can prevent gatherings, normal social gatherings and things like that, even of people who are well at the time.
So the president is the successor of the governor for these purposes.
Yes.
And the board has become
the minister. The Minister of Health.
Yeah.
It is rather odd because later on there's a provision that says if the minister can't meet, then the president can do things on an emergency basis. But, my lords, I don't think much turns on that. The minister was, board was replaced with minister, I think I'm right in saying, in 1965. We have the reference in our case. And then you'll see A, but also B. I want to show you these powers because they're really quite savage, some of them, at least on the face of it. The removal to hospital and curative treatment of persons suffering from any dangerous infectious disease, well, that may be said to be fairly normal. But then the removal, disinfection, and destruction of personal effects, goods, houses, and other property exposed to infection from any dangerous infectious disease. And that obviously, the notion that your house could be removed or destroyed is obviously a very wide power, but obviously very much in the nature of an emergency power. Then the speedy burial or cremation of the dead, house-to-house visitation and inspection, provision of medical aid and accommodation, promotion of cleanliness, and the prevention of the spread of dangerous diseases at sea. It's basically H. And then I, a catch-all. The doing of any such matter or things may appear advisable for preventing or checking such diseases. And then there's a provision, proviso in relation to hospitals or asylums, in which case the Governor-General can exercise.
But do you understand that the removal to hospital and the curative treatment might be regardless of the consent or lack of it of the person? On
the face of it, yes. That's what it looks like. It hasn't arisen in this case, but one would imagine that would be the idea. I don't want to go to hospital. No, you must, because you've got a dangerous infectious disease. You better get out of this village pretty quick. But so these are wide and intrusive powers, we say. There's no doubt about it. And then there's a second proviso at the foot of 1308, provided further that in the event of immediate action becoming, in the opinion of the governor, necessary to deal with any dangerous infectious disease, and of its not being practicable, in the opinion of the governor, to have a meeting of the board forthwith, which you get the nonsensical provision now, it not being practicable, in the opinion of the governor, to have a meeting of the minister forthwith, the governor may, pending the holding of the meeting, take all such measures. So he can step in, so to speak, pending a meeting of the board, or I suppose pending the minister getting round to doing something. And he can do whatever the minister could otherwise do. And so the structure appears to be that the President declares the proclamation, makes a proclamation. He says there's an infectious disease or dangerous infectious disease. If it's just an infectious disease, he can then provide for hospitals and things. But if it's a dangerous infectious disease, the matter is left to the board or the minister now to make regulations, and if there's no time for that, then the President can make those regulations for him. Now, I will come on in a moment to how the regulations get brought into effect. You'll note at page 1309, for the purpose of section 132 and 133, the provisions of sections 132 and 133 shall apply to all regulations made under this section. And we do have that, I think I'm right in saying, at 1310, 132, all regulations made under this part of this ordinance shall be published in the Royal Gazette, and when so published shall thenceforth have the same effect and operation as if they were enacted by and formed part of the ordinance. And my lords, and with apologies, if I can go to, I think it's the second supplemental bundle, where you can find certain other parts of the ordinance which haven't been included in the main part, which is first of all the definitions of infectious and dangerous infectious disease, and section 167. And it's the second supplemental bundle, and it's at page 18. You have at page 18 of the second supplemental bundle the start, I hope, of the ordinance, but I just want to take you to page 19. Infectious disease, it's defined here. You'll see how it's defined, diphtheria and various other matters, which presumably were thought not to be quite so infectious as others, or presumably not thought to be, quote, dangerous infectious disease. And then immediately after that...
I think they're actually dangerous infectious diseases are a subset of infectious diseases.
Yes. Oh, yes, they must be, yes, yes. But they are, so to speak, dangerous, which attract the responsibilities of the board or the minister.
Yes, but dangerous infectious diseases lists 4 named diseases, and thereafter you say the President has to declare the relevant disease to be a dangerous infectious disease.
Yes, and that's what he did with coronavirus.
Yes, and in order to exercise, you say, the 105 powers, section 105 powers, there has to have been that declaration.
Absolutely, yes. In fact, a proclamation.
Proclamation.
And then going over a few pages, I think it's at page 22. How do these regulations get brought into effect? Let's say the minister makes regulations. How do they get actually brought into effect? 166 provides for breaches of bylaws, but it's 167. Regulations or bylaws made by the board, i.e. the minister, under this ordinance shall not take effect until they've been confirmed by the governor and council, by President, and then provision for local authorities. And then 168, when confirmed by the governor and council, all such regulations or bylaws shall come immediately into effect and have the force of law and shall be published in the Royal Gazette. So ultimately it is for the governor, or now the President, to ensure that these regulations brought into effect.
What does governor in council mean now? Has that also been adapted for the modern constitution?
I think I'm right saying president.
Just the president or the president?
Oh, in council,
In
I
council.
see. I'd have to check the definitions. Well, there would have been, there'll be something, I imagine, in one of the constitutions which would give a so to speak, a translation. I don't think there's any suggestion here that the President, in passing the regulations under 167, was, quote, in council with anyone else. But my lady, we shall have
Well,
to
it
check.
said at the start of the regulations, number 8, it
Yes.
says just confirmed by the president under section
Yes.
167. So it may mean that the governor in council is just the president.
My lady, we will check the point. We do have an example of the sort of regulations passed under these laws, under this law. My lords, my lady, and if you can take it from me, nothing like the regulations we see was brought into effect. They tend to be quite specific, in other words, dealing with yellow fever, dealing with this, that and the other. I don't propose to take time with it now, but I make the point because one of the tests which Lord Diplock said you had to look at is, quote, settled practice, as at the time of the Constitution was passed. There certainly doesn't appear to have been any general practice of passing this type of law at all. The laws tended to be dealing with individuals or groups of people who had a disease, rather than directed towards people who did not have a disease.
Mr. Knox, have we reached a convenient moment?
Yeah, the more time I have. Yes, my lord. Yes, we have.
Very well. Well, you have an opportunity to regroup, as you put it. We'll resume at 2 o'clock.